let's get more perspective now from attorney Robert Sanders, who is a senior lecturer of national security at the University of New Haven. Robert, thank you for being with us. District Attorney Fani Willis is proposing beginning the Fulton County trial in March for Trump and the 18 others indicted. The general consensus is among legal experts that that is quite ambitious. What do you see as a realistic timeline for things to play out?
Well, it is an ambitious time to try to run this trial. Remember, we're talking about 19 different defense counsels, 19 different defendants, and a team of prosecutors to work on each aspect of each individual defendant's potential or alleged violations of the law. That's a lot to be prepared for, either to defend or to prosecute by March of next year. I suspect that just based on general logistics and the fact that the main defendant, Donald Trump, has multiple other cases going on, that will slip into the later spring, early summer.
Well, Robert, Fani Willis has said she wants to try all 19 people at the same time. This is a RICO case, which the DA has plenty of experience with. But is a trial of that magnitude even possible in this case? Or, I mean, is the expectation a lot of these people won't be tried? They will turn themselves in?
Well, I don't know if it's a lot, but there's several people who are lower level pawns on this chessboard who don't see themselves spending 5 years in jail and paying a maximum of $20,000 on their accounts. They can see themselves doing a lot less time, maybe even some into probation, if they cooperate with Attorney Willis. And that could be for their benefit. Of course, that's to the detriment of Donald Trump, but that would take that number of 18 down potentially substantially.
Right. Well, the former Trump chief of staff, Mark Meadows, is already trying to move this to federal court. So what are the chances of that succeeding, not just for Meadows, but now for Trump and many others who might want to take that approach? At least his lawyers may want to take that approach.
Well, one of the criteria in order to move this case to federal court is that the activities of the defendants were actually inside the scope of their duties. I think that's a hard stretch for Mark Meadows to prove that the things he was doing in Georgia in terms of tampering with the trial and talking to legislators about how he thought or wanted them to act was inside the scope of the chief of staff for the then president. Now, for Donald Trump to subvert our election and to run a scheme across the nation that resulted in a rebellion, an insurrection, to say that's inside the scope of his official duties which is ludicrous in my opinion. And you think about the fact that he, like I, swore an oath to defend the Constitution of the United States of America against all enemies, foreign and domestic, would be a laugh in the face if they were to accept that from Trump. Meadows, he could probably prove some of the activities he did were in the scope of his duties as the chief of staff, but many were not, and that's his rub.
I see that point. All right. Well, I want to ask you about that federal case, the election interference indictment brought by special counsel Jack Smith. Smith wants the trial to start in January. Now, Trump's lawyers have already asked for a trial date of April of 2026, so well over 2 years from now. What do you see District Judge Chutkan actually deciding at that hearing coming up later on this month?
It will be closer to what Special Prosecutor Smith has asked for and far away from what Donald Trump's lawyers are seeking. This will not be pushed out into 2026. The latter part of 2024 is probably a more realistic timeline given the nature of the cases against Donald Trump across the nation.
Now, with that particular trial, if Trump were to be convicted and say he becomes president of the United States, we're looking at a whole different situation where a pardon could be a real possibility. He could pardon himself, correct?
Any Republican president in the future could potentially pardon Donald Trump. Here's the rub. There are legal scholars right now who are contending that as we sit here today, Donald Trump is not even eligible to run for president because under the 14th Amendment of the United States, particularly Clause 3, it says that if you are sworn oath, as the oath I just mentioned, and then later participate in an insurrection or rebellion against the United States, that makes you ineligible to serve as president, vice president, or senator or congressman going forward. So the argument is now being posed. There's actually two law professors at the University of Pennsylvania Law School who are writing an article, which should come out very soon. Professor Tribe, who is one of the foremost constitutional lawyers in the United States, and the attorney who advised the judge that advised Vice President Pence to not do what Donald Trump asked for, both believe that what these Pennsylvania law professors are putting together may be factually true and be holding of the 14th Amendment, which would bar Donald Trump from running. So we may never get to that last piece, because if that first part happens and the Supreme Court, again, tough piece here, Supreme Court accepts that, Donald Trump, as we sit here today, would not be eligible.
Okay, plenty of twists and turns, I'm sure, to come. Attorney Robert Sanders, Senior Lecturer of National Security at the University of New Haven. Thanks so much for your insight tonight. We appreciate it.
Glad to be with you. You take care.